Whether it's a complaint about a fellow surgeon botching operations or about a manager distorting waiting times, NHS whistleblowers are meant to be protected by law. They're not allowed to be gagged. But as we've discovered, the reality is very different.
Obviously, gagging of whistleblowers shouldn't happen, but it is a way of suppressing and keeping the problems down the bottom and preventing them getting up to the top where they could be resolved.
It's very much the case, yes. People are frightened to speak out because they're frightened for their jobs.
Doctors we have spoken to have told us some trusts are ignoring the whistleblowing rules. We've also discovered that millions of pounds of taxpayers' money are being spent on legal settlements that effectively prevent doctors from speaking out, that gag them from talking about issues as important as dangerous practices or procedures. Whistleblowing policies are there for the protection of the patient and for the good of the NHS, and this is what's supposed to happen. If an employee raises concerns, these are meant to be investigated and there should be no reprisals. Yet we can show that this is simply not happening. For a start, using the Freedom of Information Act, we discovered that in the decade to February this year, at least 170 doctors signed settlements with their trusts. We were given 64 heavily blacked out contracts. 55 contained gagging clauses. That's nearly 90%. How many involved whistleblowing, we don't know. But from discussions with doctors and medical law experts, we know that staff who blow the whistle are often asked to sign these confidentiality contracts. And this means, of course, that hidden from the public is that a doctor may have left because they had genuine fears for patient safety.
There's no doubt that this child's death was a tragedy and that he suffered terribly at the hands of his carers during the last months of his short life.
And there, in the midst of some high-profile scandals, has been the issue of gagging clauses. In the baby P case, a locum at St Anne's Hospital in North London failed to spot injuries that led to his death. Yet the paediatrician Dr. Kim Holt, with 3 colleagues, had earlier raised concerns about the hospital. She was reportedly later offered £120,000 to leave and stay silent, which she refused, although the hospital denied the payoff was an attempt to gag her. There are government guidelines on whistleblowing, but should they fail, and they do, there is the Public Interest Disclosure Act, or PIDA. This is the government's guarantee to the whistleblower, a piece of legislation that's meant to say you will not be sacked for whistleblowing. We've learned of 19 NHS staff who blew the whistle, went to an employment tribunal, all using PIDA, but who settled before the case could be heard. It may not sound a lot, but these are all people who decided to take on their trust because they felt they were not being listened to. But this would appear to be just scratching the surface. Channel 4 News has spoken to NHS insiders who suggest that only a small proportion of whistleblowers ever go to court. In Wales, we met Lucy Dawson, who's one of the few willing to speak out on camera. An A&E doctor at Neville Hall Hospital in Abergavenny for 17 years, she raised concerns in 2006 about a clinical incident, which she expected would be handled under the Trust's whistleblowing policy.
Had I not been there and had the other middle grade not been there, then it's my belief that that patient may have died.
She brought 2 sets of proceedings before the employment tribunal, one of which involved her whistleblowing claim and how it was dealt with. Before either case could be heard, Dr. Dawson was offered a payoff, but only if she signed an agreement with a gagging clause. She refused.
I didn't think it was right that I should be forced to sign an agreement which made me keep my mouth shut about what's going on. I wouldn't have been allowed to speak to anybody other than my husband about any of it.
Dr. Dawson's case is complex, involving a number of issues and allegations on both sides. But she says this is not just about her.
I cannot see a reason why in a public organisation which is funded by taxpayers' money, why there isn't absolute transparency. I cannot think of a single reason why anybody should be paid to keep their mouth shut.
Fearful of the potentially huge legal costs, Dr. Dawson dropped her cases and later resigned. She now works as a locum, but she remains convinced that her initial concerns were never properly addressed. She contacted her MP David Davies, and his own investigations have since revealed 13 settlements in his own local health board alone, and over the space of just 4 years, though not what they related to.
What I did was to examine more widely the issue of so-called confidentiality clauses, gagging clauses if you like, and it does seem from what I found out that it's almost standard procedure. I've got a freedom of information request suggesting that it's been used several times a year in one local health board, my local health board alone.
The Aneurin and Bevan Health Board, which runs Neville Hall Hospital, said it has a policy of not using confidentiality agreements in respect of settlements reached. During our investigation, a more worrying trend emerged. Instead of dealing with issues raised, some trust managers attempt to discredit the whistleblowing doctor.
The trusts find something upon which they can influence this individual and hold them virtually to ransom and say, you speak up and all this will happen. I mean, it's effectively a form of bullying, if you like. But we do hear about these sort of things occurring, and gagging as an entity, as an event, has to be wrong.
Certainly this is what happened to one whistleblowing doctor who was gagged and has to remain anonymous.
As soon as concerns were raised, an accusation was raised against me. It was of a personal nature, personal misconduct. I felt my family was suffering totally innocently. But eventually that was dismissed. And as part of that process, a compromise settlement was offered. And that settlement contained a gagging clause.
David Bowles, who was chairman of a large NHS trust until he resigned in 2009, objects to what he sees as the improper use of confidential settlements.
You shouldn't be at a position of needing a compromise agreement with a whistleblower. You should never get to that point in the first place. You should have listened to the concerns and you should have managed them in accordance with the legislation and indeed the NHS's own published code. I think it's endemic. And I think Andrew Lansley has a huge problem on his hands in terms of tackling that culture.
Health Secretary Andrew Lansley has acknowledged that the scandal of Mid-Staff's hospital was allowed to continue because whistleblowers were ignored. One of them was even suspended, while the official inquiry report said another whistleblower was given inadequate protection and that there was a culture of fear. Our request for an interview was refused, but a Department of Health statement said,
"The Health Secretary has made it clear that patient safety should be at the heart of the NHS and that the improvement of whistleblowing policies is a key part of this. He has therefore taken action to give teeth to the protection available under the Public Interest Disclosure Act and will reinforce the NHS Constitution to make clear rights and responsibilities in respect of whistleblowing."
But Mr. Lansley has also made it clear that he will not be changing the law. Yet all the evidence we've seen is that trusts have been simply ignoring the rules, devastating the careers of doctors, costing the NHS millions, and putting unknown numbers of patients' lives at risk.